All right, our final speaker of the day is Irene Bassel Frick of Akerman Senterfitt in Tampa, Florida. Irene is a commercial litigator with trial experience in both state and federal court, arbitration proceedings, and administrative proceedings, and Irene represents clients in all aspects of commercial disputes, including contractual disputes, fiduciary duty claims, and business torts. Irene has significant experience representing lenders and financial services clients in defense of lender liability claims, and enforcement of commercial loans and prosecution of commercial foreclosures, appointments of receivers, bankruptcies, and delinquency litigation. She also has experience in employee benefits litigation, including ERISA, and in construction litigation. Irene also represents architects, engineers, and contractors in preparing and filing claims of lien and or claims on bonds, standing between you and your summer weekend, presenting on ethical considerations when a lawyer is a witness. Please welcome Irene Bassel Frick.
One thing that was not mentioned is the fact that I often represent lawyers. And what I'm here to talk to you about in this final stretch is the ethical pitfalls when the lawyer is the witness. Some courts have observed the increasing use of lawyers as witnesses and identified the risks associated with that. There are fundamental ethical responsibilities and principles that apply when a lawyer is a witness that don't necessarily apply to other witnesses. Primary of which is the rule of confidentiality, which is codified in Model Rule ABA Model Rule 1.6, which prohibits the disclosure of confidential information without a waiver or a consent. The rule of confidentiality is given effect by related bodies of law, and they are the attorney-client privilege and the work product doctrine in a judicial setting. And these rules may cause a lawyer to feel like this. Since we're analyzing the ethical implications when a lawyer is a witness, we're going to concentrate on the two related bodies of law that apply in this setting, and they are the attorney-client privilege or the work product privilege. The Seventh Circuit, in a recent case, Sandra T.E. versus South Berwyn, citing the Supreme Court of Upjohn, reversed a trial court and actually protected attorney-client privilege communications and work product. The trial court in that case had determined that there was no attorney-client privilege and no work product, and the trial court's decision actually exemplified the saying that we often hear, that bad facts can sometimes result in bad law or bad decisions. The South Berwyn case is reminiscent of the Jerry Sandusky facts that have recently been the subject of a lot of media attention. In South Berwyn, an elementary school teacher was charged with numerous acts of sexual abuse of students over a period of many years. A civil suit was filed by many victims against the school district and the principal, and the allegation was that they knew or should have known what was happening and they didn't take appropriate action. The board, in response to that, hired a law firm to conduct an internal investigation and provide legal advice. There was an engagement letter that was sent, and the engagement letter provided that the law firm was undertaking the investigation for the purpose of rendering legal advice. That engagement letter was unfortunately discounted at the trial court level. The law firm interviewed employees, both former and current, and third-party witnesses. They didn't record any of those interviews. Instead, the attorneys took notes and then later drafted memos that summarized those interviews. In the meantime, the school board had sent a letter to the parents informing them of the investigation and that the investigation had started and would be completed as soon as possible. The implication being that the investigation was going to be made public. The law firm eventually delivered an oral report at a closed session and then later delivered an executive summary, and it was clearly marked as attorney-client privileged and work product privilege. The trial court, in that case, found that the law firm was acting not as lawyers, but as an investigator, and they were specifically concerned with that letter that went out to the concerned parents. Yet the law firm continued to resist all discovery that was served on the law firm, and they relied upon the rule of confidentiality. The Seventh Circuit, relying on the Upjohn holding, held that a factual investigation performed by attorneys, as attorneys, falls comfortably within the protection of attorney-client privilege. And the law firm was, in fact, acting as a lawyer pursuant to that engagement letter that the trial court had discounted. One of the things that the lawyers were asked to reveal was the information that they had obtained through their client interviews or through their employee interviews. And in that case, the law firm had complied with Upjohn and given those Upjohn warnings, and we've heard those referenced today. And basically, they told the employees that the lawyers represented the school board, not the employee, and that the school board controlled the privilege, and whether the communication would even remain privileged. Relying on the acts of the law firm in the interviewing of the employees, both current and former, the court found that the attorney-client privilege did apply. And one of the fundamental reasons why we have the attorney-client privilege, as recited by the Seventh Circuit in the South Berwyn case, is to encourage and promote the public interest to have clients conform their future operations to the requirements of the law and potentially to pursue remedial options. The fact that it was a public entity did not change that analysis. The court also found, the Seventh Circuit also found in South Berwyn, that there was an independent basis to assert a privilege based upon work product. Found that it was often broader than the attorney-client privilege, and it actually protected the mental impressions and thought processes of the lawyers. And unlike the attorney-client privilege, it also found that the attorney has an independent privacy interest in the work product and may assert work product on the lawyer's own behalf. So now that we have that basic framework, the question is, can a lawyer testify? In general, the answer is yes. Simply because a lawyer is a lawyer does not mean that a lawyer can never be called to testify. ABA Model Rule 3.7, though, prohibits a lawyer from acting as an advocate at a trial, absent some limited exceptions. Now, the model rule also provides that a lawyer can be an advocate in a trial where another lawyer in the firm is going to testify. Why do we have this rule? Because of the potential conflict that exists if a lawyer's testimony is at odds or has the potential to be at odds with his own client. Now, there are situations where a lawyer can be compelled to testify by the opposing side, but there are other situations where a lawyer is actually put forth to testify on behalf of the corporate client. Should a lawyer serve as a corporate representative? Fortunately, the answer to that is it's complicated. It's a really fact-specific analysis, and often corporations or the client makes the decision it's most expedient to have the lawyer testify, the in-house counsel testify, or serve as the corporate representative because they can best synthesize the corporation's knowledge regarding the specific matters. Otherwise, the corporation may have to designate several different persons to testify with respect to the different matters. Is a privilege waived simply because a lawyer serves or is designated as a corporate representative? Every court that has considered this question has answered that no. However, parties are going to continue to make this argument simply by virtue of the fact that a lawyer is being designated as the corporate representative results in a waiver of the privilege. Because the argument goes, how can a lawyer separate out privileged information from non-privileged information? There's the Adler case that's cited in the materials, and in that case, the general counsel for the corporate, one of the corporate parties was designated as the corporate representative, and he actually testified regarding statements made to him that would have otherwise been protected by the attorney-client privilege. The court in that case held that once that door was opened, the general counsel was required to disclose his advice to his client in response to those statements. So the risk, if you're going to designate a lawyer as a representative, a corporate representative for purposes of trial, is that there's a potential waiver that exists. And once you open the door, you potentially waive any privilege that exists with respect to that particular matter. There's also an argument that's raised, I'm going to take a little detour right here, regarding unsworn witnesses. And this is a theory that is often used by parties in seeking to disqualify a lawyer who has personal knowledge of a matter and through their demeanor and questioning can suggest the lawyer's view on the matter. And the danger is that the lawyer, the unsworn witness, so to speak, can subtly impart firsthand knowledge. For example, if a lawyer calls a witness to testify and in response to a statement from the witness says, that's absolutely correct, there's an implication that it's the lawyer's question or the lawyer's response that represents the truth. And the opposing party cannot clarify counsel's testimony or impeach credibility. That's one of the reasons that we have that Model Rule 3.7 that prohibits a lawyer to testify in a case in which he's going to be a necessary witness. The unsworn witness argument, as I said, often used in situations where an argument is being made to disqualify counsel. And it often arises in the context of a lawyer conducting witness interviews very early on in the process. One way to protect against an unsworn witness argument for disqualification is to make sure, if you're going to be conducting witness interviews, make sure you have a third party present. Let's go back to whether there's a waiver of the privilege. When there is a designation of a lawyer as a corporate representative, the concern is that there's going to be a waiver of privilege, and that was exactly the situation in the Adler case. In the Adler case, the corporate representative testified as to statements made to the counsel and then had to testify about his responses to those statements. The court found that there was a waiver in that context. There's another case that is cited in the material, the Avery Dennison case, and it's a patent infringement case. And in that case, there was the corporation's in-house patent counsel was designated as a corporate representative and testified over 11 days in a span of 1 year and consistently refused to answer questions related to the potential overlap of the patent that the plaintiff was attempting to enforce against the infringing party. But on the 12th day, they answered those questions. And the court found that once there was a response to a particular matter that potentially fell within the attorney-client or work product privileged area, there was a waiver as to everything related to that matter. There are two other instances or two other factors that can result in a waiver of the privilege. One is when a client asserts reliance on an attorney's advice as an element of the defense or claim, or when the client places the attorney-client relationship at issue. In those cases, they typically involve an argument or a defense or claim that's raised that a party acted in good faith, and they acted in good faith and reliance upon counsel by their lawyer. In those cases, courts have found privilege. If you're going to specifically put it at issue, you're going to have to answer all kinds of questions about it. Courts have also found that there have been waivers of privilege when there have been disclosures to the SEC or the IRS. So if there have been communications or reports or filings that reference a particular matter that is later litigated and it's been somehow disclosed, or the advice of counsel is disclosed in the filing, courts have found a privilege waiver in those cases. Practical advice: when conducting an investigation, follow the South Berwyn case. Make sure that there's a confirmation in writing, an engagement letter stating that you are conducting a fact investigation for the purpose of rendering legal advice. Also give those upjohn warnings. If you're going to testify, if you're going to designate a lawyer as a corporate representative, make sure you stick as close as possible to the topics that have been identified. Also refuse to answer questions that invade on the privilege. A lawyer can be compelled to testify. And should you seek a protective order? Those questions go hand in hand. The answer to that is know the jurisdiction that you're in. In some jurisdictions, courts have turned the burdens on themselves. They have flipped the burdens of proof with respect to motions for protective order. Generally, a party that seeks a motion for protective order has the obligation of establishing the basis for that protective order. However, there are a line of cases that follow the Shelton rule, the Shelton case that's cited in your materials. And these cases actually put the burden of proof on the party that is seeking the deposition of the lawyer. This is not a situation where a lawyer has been designated as a corporate representative. This is a situation where an opposing side is seeking to depose a lawyer as a witness in the case. And the courts that follow the Shelton rule generally say that if you want to take the other side's lawyer's deposition, or you want to call him to testify at trial, you have to demonstrate that the information is relevant and not privileged, there's no other means to obtain the information, and it's critical to your case. Now, we started off by identifying the different ethical rules that apply. If there is a violation of an ethical rule when a lawyer serves as a witness, the possible implications are disciplinary action, waiver of privilege, or disqualification. As we've said, there are many risks inherent when a lawyer is called to testify. So if this should happen, you have to be very careful. Thank you.